in such a way that would take away rights previously guaranteed. What seems to
2. Testing 1, 2. Shalom, shalom, people. Sorry that took so long. Had some things to do. Now, before I get started, I'm gonna do that second part to the Constitution, yada yada with Carmilla. Before I get started, I just want to say, right, that it's been years. I was supposed to start doing this years, but I kept putting it off for whatever reason. No fucking excuse. Doesn't really matter what it was. But I want to say to anyone who wants to listen, anyone who wants to do something, just fucking do it. Just do it, right? Don't put it off. Don't put it off. Don't let anything stop you from doing what you want to do. You heard? Don't let nothing stop you. Do what you want to do. Get it done. Don't let anybody get into your head and, whether directly or indirectly, keep you from doing what it is you want to do. Whether it's this bullshit podcasting, YouTubing, starting a business, whatever it is you want to do, just get it the fuck done. You heard? Because people are crabs in a barrel, and they'll make you feel crazy about what you want to do. So with that, I'm gonna I'm That's what we're going to do now. All right. And again, remember what I'm telling you. Don't let nobody stop. Do what you got to do. I've been trying to do this, and I ain't been trying. I just haven't done it. Years, at least a fucking decade, that I've been contemplating doing this whole bullshit. So I didn't get it done, right? Because again, I was bullshitting my time away. I'm telling you, don't do that, all right? All right. This is part two. It's going to be 3 other shorts. Carmilla, get your pens out. Take notes. This is about the law and how it applies to you. We ain't going to waste no more time. Let's get into it.
Be Mr. McCollum's problem. Does he not read the King's English? Excuse me. Simply spoken, he has no authority to pass this 666 bill. The Congress had no authority to pass this Brady bill. They had no authority to pass this crime bill because it clearly infringed on the United States Constitution. I don't care how noble the issue it was. I don't care how learned the people claim to be. They weren't learned enough. Because if they were learned, they would have understood the Ninth Amendment forbids adding on to the Constitution by any laws whatsoever that takes away rights that are previously guaranteed. Excuse me. Now, let's go on. Let's hit the 10th Amendment. The powers not delegated to the United States. What are they talking about here? The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. See, this is a limited contract. This contract is designed to limit government. And when you get into your police powers, you start understanding your police powers. Almost you'll hear this all the time. Well, we have police powers. Broad and sweeping police powers. You look up Black's Law Dictionary police powers. It says the law of eminent domain of a state or political subdivision to enact laws for the common good and welfare and to curb crime. And in great big black letters it says within constitutional limitations. See the 10th Amendment. Well, when they're talking about see the 10th Amendment, this is the 10th Amendment they're talking about. Now, do they have powers to take away previous rights guaranteed under the Constitution? The answer is obviously no, they don't. Obviously, the 9th Amendment sets a clear limit on that. What is it these guys don't understand about their Constitution? They pass these Brady bills, they pass these crime bills, they pass these 666 bills to take away your 4th Amendment right, requiring a search warrant. What is it that they don't understand about the locks on the Constitution? Now, do you see how wise our forefathers were? They knew history, and they knew that history repeats itself if people forget. So what they did is they set a standard, very importantly, toward the end of the contract that clearly stipulated exactly what limits would be there, you see. And it clearly stipulated that no power has existed to take away rights that were previously guaranteed. So how, therefore, is this being done? I'll tell you how it's being done, because they wants to. And they're not doing it by law. Now, why are they getting away with it? Because most of the people don't know any better. And if you don't know your rights and you don't timely assert them, laches incurs. Laches being a species of action wherein a party of reasonable intelligence and integrity having a right to take an action as is prescribed by law, and having failed to timely do so, loses all right to proceed.
So basically, learn your fucking rights, people, and assert them. Because if you don't assert them, you don't have them. I said that in the last 3 videos. Well, the last video with the 3 shorts in it. Learn your rights. Know what they are. Exercise them. Because if you don't have them. So it's important that you learn what he's talking about. I mean, I would tell you to take notes, right? I talk a lot of shit to police and the judges and the prosecutors and anybody else in the court. And I'm not a criminal, right? I don't have any, right? Mostly dealing with lower court. But I tell them all to go fuck themselves. Every silly though. Don't go in yourself. It hold you in contempt. But you can assert them. Um, whenever I get shook up, I just invoke my Fourth Amendment right and my Fifth Amendment right and my Sixth Amendment right in case they want to take me to trial, speedy trial. But that Fifth Amendment, that one is superior because once you invoke it, all you got to do is shut the fuck up. They can't ask you any more questions, or you could sue. So learn your rights, people, because without it,
so by you acquiescing, by not jumping up and saying, "Hey, hold the line, Chester. You ain't touching that Fourth Amendment. You aren't touching that Second Amendment. We're not putting up with that stuff. You took an oath of office, we're going to hold you to it. You violate that oath of office, we're going to charge you with capital felony treason under Title 18 United States Code Section 2381. What difference does it make if they're in open rebellion against the United States or if they're breaking down the laws creating a rebellion? Isn't that giving aid and comfort to the enemies of our country? It most certainly is. And it's called sedition. Treason by sedition. Okay? Now we got to start collaring these guys and telling them, hey, what is it you don't understand about the Constitution and your oath of office? We're going to clearly correct that in the short interim. And if you don't want to fix it, we will remove you.
That's right.
And that's our duty and our responsibility. Now, when Benjamin Franklin walked out of all of the hearings to set up this Constitution, a lady reporter walked up to him and asked him, what is it we have now? And he turned to her and told her, we have a republic, if we can keep it.
If we can keep it.
Obviously, the burden is on us to make sure we keep it. So I'm asking you to get a hold of one of these constitutions and let's plan on keeping it. All right, now let's get into some more of the arguments on the Constitution. Your Fifth Amendment. Let's pull up your Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war, or public danger. Nor shall any person be subject to the same offense be twice put in jeopardy. That's the double jeopardy statute. Of life or limb. Nor shall be compelled in any criminal case to be a witness against himself. That's a self-incrimination defense. Nor be deprived of life, liberty, or property without due process of law. That's your Equal Protection Clause. You have an equal right to all of your rights under the law, and you have a right to due process of law. Matter of fact, if they don't give you due process of law, Title 5 United States Code Section 556D is clear and specific, and it says if they deny you due process of the law, all jurisdiction ceases automatically. That's Title 5 United States Code Section 556D, also 557 and Section 706 of that code.
Without your rights, they can like to what was her name? Sonia Massey. Look what they did to Sonia Massey. They violated the shit out of her rights. Notice how he can rattle all of this off, right? Codes and subsections and all that other shit, right? So you think they're gonna violate his rights? Of course, he's a white man, and knowing his rights on top of that, secures him in a way that we can't be secure because they don't give a shit about us. But when you stand before the court, if you can assert your rights, like he says, in a timely and effective manner, they have to honor them. So let's learn this shit, people. I'm right here with you trying to learn it again. Because again, I talk shit to the cops. Anyone who knows me well, knows very well or full well that I will tell a cop to go fuck himself. that I will declare my status as a law-abiding NRA card carrying American, and I know full well all of my rights. And when I want to be a dick, I just invoke the fifth. Anyway, let's get with it.
In other words, if they deny you due process at any time and you can prove it, you can force a showdown, and you can turn around and say, well, they might have had jurisdiction at one time, Judge, but they lost it when they denied me due process.
Due process.
All right? Now, the other parts are, you cannot deny them life, liberty, property without due process of law, nor shall private property be taken for public use without just compensation. You know, how many times do you hear about that today? I mean, it's incredible. The Sixth Amendment is another important one. All of them are important, but there are more important ones, all right? In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the action and accusation, to be confronted with the witnesses against him. That's the right to confront your accusers. To have compulsory process for obtaining witnesses in your favor. That's the subpoena rights. And to have the assistance of counsel for your defense, or you can stand as your own counsel. And I know they tell you that it's a fool that stands as his own counsel, but it's my argument that it's a fool that doesn't. Because I'll tell you why. You know your case better than anybody. How many times do you hear about gripes between attorneys and the citizens? The biggest gripe they have was, well, he never said nothing about that, or she never said nothing about that. Well, she didn't do this, or she didn't do that. Well, why? Because they don't know the case as good as you do. You're the one that knows your best case. The only thing they know is how to apply the law. So all I'm telling you is learn how to apply the law and your constitutional rights, and then you don't need to do that. The only time you get into trouble is if you run your mouth too much and you get into self-incrimination. So obviously you have to keep your wits about you and watch your mouth. But the bottom line is, actually, I personally believe you're the best person to present the facts of your case, because you're the best person that knows all the facts. The only thing you know how to do is how to actually do it in a legal and lawful manner that is recognized by the legal community. And that's really not hard to learn. I can teach you, believe me. All right, the Seventh Amendment. In suits of the common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. It's supposed to say shall remain. And no fact tried by a jury shall be otherwise re-examined in any court of the United States, because the jury is the ultimate trier of fact. Then according to the rules of the common law. Now, we'll get into that common law argument. There's a lot of heavy arguments around that common law. Basically, I don't want to overwhelm you on the first time out of the chute. Because that's not hard to do, okay? Now, the bottom line of this Constitution is it's all in writing. It clearly represents a contract. I'm asking you to learn your contract. I'm asking you to learn the book. Learn your contract. I mean, when you go to some place to do some work on your car, you read the document that comes with it for the warranty, don't you? Why? Because just in case something goes wrong, you want to be able to bring it back, right? Well, I'm asking you to read the warranty on your Constitution so that you can understand the rights that you have under that Constitution. So that if you don't get it right, we can bring it back. Does that make sense to you? All right. Now, it's also important that you understand that this Constitution is a very unique document, and that this Constitution is supposed to be enforced, and I'm going to teach you some things here right now. This is a program, I don't know how it's coming out here. This right here is representation. I know it's kind of hard to see here, but basically what we're talking about here is this comes from the books that tell the judge how, right here and over here, this comes and tells the judge how the Constitution is to be interpreted. This is from the Am Jurisprudence volumes, and this is volume 16. You want the constitutional law section right here, constitutional law, and you want section 97. And when you start reading it, the most important part about it, and I'll read it, is that a constitution should receive a liberal interpretation in favor of the citizen is especially true with Constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. Can you see that? Can you all see that? Is that coming out right here? Over more. Okay. All right. To safeguard the liberty and security of the citizen in regard to both person and property. See Note 31, Briars v. United States, 273 U.S. 28, and all of these 40 Supreme Court cases hold that axiom. In other words, it's supposed to be liberally enforced in favor of the citizen for the protection of rights and property. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. 32. Go down 32, DeJammer versus Hospital Authority of Albany in all of these cases. Okay, you can see that? All right, help me out here. Okay, is it in? All right. I'm just trying to tell you. You can go look this up and you can better see it. Can you see it clearly now? Okay. All right, now, let's do that over again. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. Similarly, a provision intended to afford a remedy to those who have just claims should receive a beneficial construction for the purpose of extending the remedy to all who might fairly come within the meaning of the terms. And that's Ryder versus Fitchie of Ohio, a Supreme Court case, okay? That's note number 33, okay? Now, this comes out of 16th Am jurisprudence. In other words, I have this Constitution. This Constitution is a contract in writing enforceable in the court of law pursuant to the statute of frauds. I'm asking for specific performance, Your Honor, in favor of me. I am the beneficiary of the contract. There's also a basic premise in contract law, Basic Contract Law 101 of any first-year law student, that says the contract shall be enforced most favorably in favor of the non-preparer. And that's you. You didn't prepare it. Now, if you believe honestly that you have a right, and you can timely bring that right before a proper adjudicated authority, and you can clearly stipulate as to what your right was, guess what? They gots to listen. That's the way it is. That's the way it's supposed to be. And I'm telling you, if you know your rights and you timely assert those rights, you have those rights. But if you sit on your haunches and you cry foul, that's terrible. Somebody ought to do something about that. Hey, be a somebody. Do something about it. Don't sit there telling me somebody ought to do something about that. Be a somebody. You do something about it.
Word. That means be the change you want to see. Become the change you want to see. And that's what I was talking about earlier. When you want to do a thing, just fucking do it. There will be people that are gonna try to like talk you out of what you want to do and tell you how impossible it is, and most of them gonna be related to you. Don't let them do it to you. Do something. See something, say something. And by that I mean in regards to the violations of the rights. I don't mean be out here snitching on motherfuckers and telling, being a tattletale ass nigga. That ain't what I'm talking about. I'm saying that when there's an injustice, uh, you should speak out on it. If you can't correct it with your hand, then you should speak out against it. Um, we had great leaders at one point. I wasn't alive to see Malcolm or Martin or Medgar or Hampton, Fred. Fuck was his name? I can't remember his name. Black Panther, young boy, young man, making moves, making real moves. Um, I wasn't around, but they spoke out. They mobilized. They tried to do a lot of shit for our people, both black and brown. And again, I know y'all see me, y'all see this pasting nigga and be like, who the fuck you mean our people? I mean our people. So that you're clear, right? By our people, I'm one of those. Yo soy Boricua. And I understand that the so-called black African American man, woman, and child, the so-called Latino of indigenous descent, and the so-called Native American, we are one people. Now, not a lot of people believe that shit. Not a lot. Only a remnant, a small few believe it. But that's okay, because 2/3 of the motherfuckers from our people who don't believe that, they gonna die here with the rest of the heathen. Right? But let's not get into that. Let's finish this again. Learn the law, learn your rights, learn all that shit, and teach it to your families. And be willing to fight, bleed, and die for it. Otherwise, it's just pointless.
You honestly got an honest bitch, you go out there and you take care of it. Because that's what it takes to be an American. That's what it's all about. That's what being an American is all about. That's what separates you from the rest of the whole world. Because Americans, you don't trample on their rights because they're going to come get you. You do not trample on their rights. They won't put up with it. So be an American. Don't put up with it. Stand up there and be counted. Now, I want to read the next argument there, which is argument number 98, which basically deals with the effect of an emergency. Argument 98. Does everybody see that there? Get it there? Pretty good? All right. Argument 98. While an emergency cannot create power and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions, public emergencies such as economic depression, all right? I'll go over here to the next page. What happened here? All right, let's go. For especially liberal construction of constitutional powers, and it has been declared that because of national exigency, it is the policy of the courts in times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution, right? In other words, they can't be in conflict with the Constitution, to vest extraordinary powers in the chief executive. But I'm telling you, on the other hand, a contention that a grave emergency such as the Depression should permit construction of the constitutional provisions which would meet the emergency was rejected. In one case, the court holding that neither the legislature nor any executive or judicial officer may disregard the provisions of the Constitution in cases of an emergency, where the plain and unequivocal terms of the Constitution present to question of construction as to departures in emergencies. So not even an emergency justifies the taking away of constitutional provisions. And I know you've heard differently.
Not even an emergency.
You think, well, they got an emergency. They just declared an emergency, and then the president issues an executive order. But let me ask you, if it's repugnant to the Constitution of the United States, is it law? No. Who says so? We do.
We do.
People. It's our country.
We the people.
It's our Constitution. We're the ones that say you can't do that. And we mean it. You better listen. All right, now.
I like this guy.
Let's get into the next argument here. Now, I hope I'm not boring you to tears here, but it's kind of important that we cover these basic things so that you can understand. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed with reference to the common law. That means the law of the little people out there, not the corporations. Okay? Since in most respects the federal and state constitutions did not repudiate but cherished the established common law, this fact has been taken into consideration by the courts in construing certain clauses in a state constitution, such as the provision securing the right to a jury trial. Also, provisions in regard to crimes have been interpreted with reference to the common law rule that one charged with a crime may be convicted of a lesser offense necessarily included in the crime charged. In such cases, the courts of the state always regard the language in the common law sense. So the common law prevails. Don't let anybody tell you this admiralty law prevails, because it only prevails if you get sucked into it. We're not going to let you do that. We're going to teach you how to beat it. The common law also permitted destruction of the abatement of nuisances by summary proceedings. Traffic tickets, folks.
Traffic tickets. I was just about to say when he said that. Admiralty law. When you go before a court, right? Like anybody who, you go before a court, whether it's high court, low court, whatever the fuck. It's all under Admiralty maritime law. You'll know it by the flag that they flying in there. You'll see those fringes on the flag. That means it's an Admiralty court. All crime is commercial. You're welcome to look that up. And it's about money. It's about commerce. You have to be able to challenge the jurisdiction and bring it back to federal court, where common law, what he's talking about, where the common law is the law and it prevails. That admiralty shit doesn't play as long as you know what you're doing, like what he's saying and what you read. That's what I'm saying. Take notes because you'll be able to defend yourself. At least be able to have a fighting chance when you go before these bastards in the court.
That's what a traffic ticket does. It is a writ of assistance, a bill of attainder. It's unlawful in the United States of America. Unlawful. And it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense, who said so? Erie Railroad versus Tompkins. Okay? All right? Of a national customary law as distinguished from the common law of England, adopted in the several states. In interpreting the federal Constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to this common law, the language of the federal Constitution could not be understood. So the common law applies, folks. And we're going to get into that common law heavily in the advanced section, all right? Okay. Now let's get back into this. In interpreting the federal Constitution, adopted by the several states, all right, the recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the United States Constitution would not be understood. This is due to the fact that this instrument and the plan of government of the United States were founded on the common law as established in England at the time of the Revolution, okay? Therefore, it is the general rule that the phrases in the Bill of Rights taken from the common law must be construed in reference to the latter. Specifically, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment, the Fifth Amendment provisions relating. All right? So the common law is extremely important that we get in, and we will cover that thoroughly. It's important to understand that most of you out there are citizens at the common law. That only those that understand the differences in admiralty and maritime law, those that are corporations, officers of corporations, or officers of government residing in the District of Columbia, the 14th Amendment duality of citizenship, which is talked about in the case of Erie Railroad versus Tompkins, which is a rather heavy argument. And I will cover that thoroughly with you so that you understand where the traps and the differences are. But for right now, I'm trying to demonstrate to you construction and programming so that you can understand that this Constitution right here is the supreme law of the land. It is a contract in writing. It is enforceable in favor of you. In an open court of law, you are the beneficiary. Okay? I want to give you some basic more points on this Am jurisprudence argument. This is section 114 of the 16th volume of Am jurisprudence second. I'm going to give you a couple more of these sites so that you can understand how powerful a document this is. Okay? Let's go to the next section, which is 115, which is let's see, which one? 117. 117 is the next serious section. They're all serious. By the way, I highly recommend you go down to the law library, grab that
Yeah. Go grab your Constitution. Grab everything that he's telling you to grab. It's important. You'll be able to really, really spit at these people. And I don't mean literally spit. I mean, you'll be able to articulate. You'll be able to speak in that courtroom in front of those agents of government. And they'll know that you know something. How Jigga said, I don't know much, but I know a little bit, enough that you won't illegally search my shit. You'll be able to spit it and never argue with a cop. A cop's a moron. Most of them anyway. Right? 8 out of 10 cops was fags in high school. They became cops to get back at the people who used to rabbit ear them, who used to pick on them. Of the 10 cops, 8 used to be fags in high school. 1 is a dedicated cop and 1 is crooked than a son of a bitch. But anyway, learn what he's talking about because it's going to help you. It really is. If it don't do anything, right? If it don't do anything but give you brass balls so when you stand in front of these people to be able to just tell them that you will not violate my rights. I know them, you will not violate them. And if you do violate them, I'll sue you under the violation of rights and the color of law. Prick. Anyway, this is the last one coming up, so let's get to it.
Serious. By the way, I highly recommend you go down to the law library, grab that 16th volume Am Jurisprudence, start at section 1 and start paging through to section 300. You will absolutely be astounded. We are now in 16th Am Jurisprudence, section 117. And I will read it to you. Basically, various facts and circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument.
Damn.
Which that militia argument and that collective law theory of the Second Amendment is. They're reaching far.
Far.
All right? Clearly it says in the plain English, the right of the people to keep and carry arms shall not be infringed. Now, what is it you don't understand about the word infringed?
Word.
They're infringing. The Brady Bill, it's infringement. The 1968 Gun Control Act, it's infringing. All of these, the CCW acts of these states, they're infringing. Who says so? You do. How shall a document be enforced in favor of who? You.
Favor of you.
When are you going to enforce it? You're the one that is the citizen. All power is inherent in the people. You're the one with the power. Enforce your power. All right? Does everybody understand that argument? That's the magnificence. I'm bringing the genie out. We're stroking the bottle here. And I'm going to bring the genie out here in a second. You're going to understand the magnificence of the power of this book. You see, once you understand this is an ironclad contract, once you understand that this is enforceable in the court of law pursuant to the statute of frauds, once you understand you have a right to claim specific performance on the contract. Your Honor, I'm demanding my right to keep and carry arms, and that right shall not be infringed. I want specific performance. I am the holder of the contract. It's supposed to be enforced in favor of me. I am the clearly intended and expressly designated beneficiary, the citizen. I want the thing protected in favor of my right. Does that make logical sense to you? Now do you start to understand the power of this document? Okay? See, before, you just thought it was a bunch of writing in some textbook that you had to take when you took a civics class in high school in the 11th grade. See, I want you to understand that you don't leave home without this. This is more important than your credit card. Okay? Next, let's get into the next section. I'm going to cover some more of these Am Jurisprudence sections so that you can understand. I want to get into section 155. 16th Am Jurisprudence, section 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, got me? Sworn? As an oath of office, sworn? The courts are not at liberty to overlook or disregard its commands or countenance evasions thereof.
So you hear that shit. They're not allowed to overlook it. Like what the Constitution says, they can't come up with their own shit. And whenever you catch a judge practicing law behind the bench, remind his ass that he ain't supposed to be doing that. Do it respectfully, because that fucker can hold you in contempt. But they can't practice law from behind that bench, right? Invoke your rights. Don't let these bastards tell you you ain't got them until they tell you you ain't got them. And that comes from like the executive branch. Like the president of the United States has to say, hey, black people, hey, Latino people, you don't have any rights. And until the president of the United States says that, fuck all the rest of them. Fuck all the rest of them. Invoke your rights.
It is their duty.
I can't say this enough, but it is their duty. You heard it.
In authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus it is said that the courts should be and are alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed. in accordance with the deliberate judgment of the tribunal before which the validity of the enactment is directly drawn into question. If the Constitution prescribes one rule and the statute another, and a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment.
You heard?
Does everybody understand that?
Do you understand
They're
that?
telling the judge, you got to rule in favor of the Constitution. And if you know your Constitution, whose favor are they going to rule in? Yours.
Yours.
But you have to have enough hair on your tail feather to walk in there and say, hey, I'm an American.
Ah, shit.
I have a constitutional right. That right shall not be infringed. And you're infringing. And I'm asking you not to do that because it's not nice. And I'm asking the judge to do his duty under his sworn oath of office and uphold the United States Constitution as he swore he would under Article 11, Paragraph 1 in this state, which says that he shall swear to protect and defend the Constitution from all enemies, foreign and domestic, and he will perform his duties to the best of his ability, so help him God. Now, let's get closer to so help him God. Let's get into another one of these. We got a load of them, folks, so let's bear with me here. 16th Am Jurisprudence, 2nd, Section 177. Declaratory judgments. Declaratory judgment actions have often been utilized to test the constitutionality of a statute and government practices. The Uniform Declaratory Judgments Act makes specific provisions of the determination of construction or validity of statutes and municipal ordinance by declaratory judgment, and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statutes and of ordinances. The Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been invoked frequently as a means of assaying the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. You can't enjoin a constitutional right. A court may grant declaratory relief unless there is a case of controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the adjudication. All right? Now, I'm trying to tell you folks here, you have a right to demand a declaratory judgment, which we are going to do in several of our cases here. And they got to declare. Is it constitutional or isn't it constitutional? If it's constitutional, it has to be judged in favor of who? You, the citizen. Why? Because you're right. the beneficiary. It's supposed to be enforced in favor of you, the beneficiary, the citizen, for the protection of rights and property. See Briars v. United States, 273 U.S. 28. And the 40 Supreme Court cases that support that mandate. Okay? Now let's get, there's just a couple more here. Bear with me. I know you're probably bored to tears right now, but I don't want you to do that. I want you to pay attention. Okay, we're at Section 255. 16th Am Jurisprudence, Section 255. In all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. The Brady Bill. Irreconcilable. Huh? In other words, the court is without authority to declare a statute unconstitutional unless it is in positive or direct conflict with the statute or with the Constitution. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. Because that would be violating the Constitution. We can't have that. What happened in Marbury versus Madison, 5 U.S. 137, same thing. A clear incompatibility between law and the Constitution must exist before the judiciary is justified in holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as to constitutionality should be resolved in favor of the constitutionality and the beneficiary, you, the citizen, for the protection of your rights and property. Okay? Does everybody pick up on that? Now, let's shift to 256. 256. Right here. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it. And wouldn't it be interesting if 34, where's 34? There's 33, where's 34? Here, 34. There's 35, all right, here's 34. State XRL versus Nguyen v. Greer. But I'll tell you what, Marbury versus Madison comes higher than that, okay? All right, 34. Let's cover that again. And ineffective for any purpose. Since the unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it, an unconstitutional law in legal contemplation is as inoperative as if it never had been passed. The Brady Bill, the Crime Bill,
The crime bill.
the 1968 Gun Control Bill, all
That
these
bill.
bills.
All that.
Such a statute leaves the question that it purports to settle just as it would be had the statute not ever been enacted. Right?
All right, people. That's the end of that one. I'll present the other tree. Damn, I said tree. I'll present the other three in the series tomorrow. But for now, just go back through it if you have to. And, learn your rights. Learn that Constitution forward and backward. And remember that when they wrote this, when they wrote the Constitution, because a lot of Israelites will tell you that shit don't apply to us, and it doesn't. It doesn't. But until they declare that openly, until the President of the United States, whether he be Donald Trump or whatever fuckbag comes after him, he has to say, hey, black people, hey, Latino people, these constitutional protections only apply to white people. They don't apply to you, your black and brown asses. They don't apply to you. Until they say that, we have those rights, knowing that they even may be limited, but we still have them. So know that, believe that. Right? Until then, I'm going to say shalom. Y'all be good. Bye, everybody.